Hello, this is R.J. Deacon reading the Supreme Court of the United States opinion syllabus in Dahda versus United States, certiorari to the United States Court of Appeals for the 10th Circuit. Argued February 21st, 2018. Decided May 14th, 2018. Under federal law, a judge normally may issue a wiretap order permitting the interception of communications only within the territorial jurisdiction of the court in which the judge is sitting. 18 U.S.C. 2518(3). Here, a judge for the District of Kansas authorized 9 wiretap orders as part of government investigation of a suspected drug distribution ring in Kansas. For the most part, the government intercepted communications from a listening post within Kansas, but each order also contained a sentence purporting to authorize interception outside of Kansas. Based on that authorization, the government intercepted additional communications from a listening post in Missouri. Following the investigation, petitioners Los and Roosevelt Dahda were indicted for participating in an illegal drug distribution conspiracy. They moved to suppress the evidence derived from all the wiretaps under subparagraph II of the wiretap statute's suppression provision because the language authorizing the interception beyond the district court's territorial jurisdiction rendered each order insufficient on its face. 251810 AII. The government agreed not to introduce any evidence arising from its Missouri listening post, and the district court denied the Dahda's motion. On appeals, the 10th Circuit rejected the Dahda's facial insufficiency argument on the grounds that the challenged language did not implicate Congress's core statutory concerns in enacting the wiretap statute. The Supreme Court held, because the orders were not lacking any information that the statute required them to include, and would have been sufficient absent the challenged language authorizing interception outside the court's territorial jurisdiction, the orders were not facially insufficient. The 10th Circuit applied the core concerns test from the United States versus Giordano and held that subparagraph II applies only where the insufficiency reflects an order's failure to satisfy the statutory requirements that directly and substantially implement the congressional intention to limit the use of wiretapping. The court identified 2 such core concerns and concluded that neither applies to the state's territorial limitation. But Giordano involved a different suppression provision, subparagraph I, which applies only when the communication was unlawfully intercepted. 251810 AI. The underlying point of Giordano's limitation was to help distinguish subparagraph I of 251810A from subparagraphs II and III. It makes little sense to extend the core concerns test to subparagraph II as well. Subparagraph II, therefore, does not include a Giordano-like core concerns requirement. That said, this court cannot fully endorse the Dahda's interpretation of the statute. The Dahda's read subparagraph II as applying to any legal defect that appears within the 4 corners of an order. Clearly, subparagraph II covers at least an order's failure to include the information required by 2518(4)A through E, but that does not mean that every defect that may conceivably appear in an order results in an insufficiency. Here, the sentence authorizing interception outside of Kansas is surplus. Its presence is not connected to any other relevant part of the orders. Absent the challenged language, every wiretap that produced evidence introduced at the Dahda's trial was properly authorized under the statute. While the orders do not specifically list the territorial area where they could lawfully take effect, they clearly set forth the authorizing judge's territorial jurisdiction, the District of Kansas, and the statute itself presumptively limits every order's scope to the issuing court's territorial jurisdiction. This interpretation of the term insufficient does not. As the Dahda's contend, produce bizarre results. Rather, it makes sense of the suppression provision as a whole. First and second judgment are affirmed. Justice Breyer delivered the opinion of the court, in which all other members joined, except Justice Gorsuch, who took no part in the consideration or decision of the case. Remember, certiorari from the 10th Circuit. Thank you for listening.